Hello, welcome to AnusheelanIAS. This is Sankirtana. In this video, we'll discuss about writs of Supreme Court and High Court, and in the end, we'll also solve some PYQs related to this topic. Now, let's go to the topic. Type of writs in Indian Constitution. What if your fundamental rights are violated? Can you go straight to the Supreme Court? Can you go straight to the High Court? Yes. That's where the writs come in. They are the guardians of our rights in the Indian Constitution. Article 32 and Article 226 deal with the writs of Supreme Court and High Court. Article 32 is called Heart and Soul of the Indian Constitution by B.R. Ambedkar. What is the difference between Article 32 and Article 226? Though both articles deal with the writs of Supreme Court and High Court, Article 32 deals with the writs of Supreme Court in case of violation of fundamental rights. Article 226 deals with the writs of High Court in case of violation of fundamental rights and other legal rights also. So, writ jurisdiction of High Court is wider than writ jurisdiction of Supreme Court. That is the major difference between the Article 32 and Article 226. There are 5 types of writs in our Indian Constitution. First is habeas corpus, meaning to have the body of. For your better understanding, we'll discuss with one example. Imagine your friend is arrested during a peaceful protest and police won't tell you where he is and under what charges he is arrested. His family files a petition in the Supreme Court or High Court. Then the court can demand produce the body or produce him before the court. That is called habeas corpus. Purpose: to release from illegal detention. That is called habeas corpus. Next is mandamus. That means to command. Example is, suppose a student clears UPSC but UPSC Commission refuses to publish her name without a reason. Then he can file a writ of mandamus forcing UPSC to do its legal duty. This is an example of mandamus, compelling a public authority, here UPSC, to do its legal duty. This writ is not applicable to the president, governor, or any private bodies. Next writ is certiorari, to be certified. When a high court to a lower court or a tribunal to squash an order passed without or in excess of its jurisdiction. Example is a tribunal punishing a student even though it had no power to deal with the students. Then a student can go to the High Court and can file a writ of certiorari. Then High Court or Supreme Court can issue a certiorari and cancel the tribunal's order. This is applicable to all judicial and quasi-judicial bodies also. That meaning to be certified. Undo a wrong order given by a lower court. Next, prohibition. That means to forbid. High Court to a lower court or a tribunal to stop its proceedings in a case beyond its jurisdiction. Example, a labor court start hearing a case about a divorce which has no power to do. Then High Court can issue a writ to stop the proceedings. What is the difference between certiorari and prohibition? Both are almost same. What is prohibition? Prohibition is given before the judgment. Certiorari is given after the judgment. Next and last writ is quo warranto. That means by what authority? to challenge illegal occupation of a public servant in the public office. Let's discuss some example. If someone is appointed as a chancellor of any university, he does not have any qualification for that post. Then a student in that university or any citizen can go file a Q warranto and ask by what authority he or she is holding that post. Can be filed by any person, not just the affected party. That is called Q warranto, means by what authority. These are the 5 types of writs. What are those? Habeas corpus, mandamus, certiorari, prohibition and Q warranto. Why are writs important? Writs protect our rights. They empower citizens. A writ without a remedy is no right at all. Now let's discuss some previous year questions. Which of the following writs can be issued by the Supreme Court to compel a public authority to perform its duty? A. Habeas corpus, B. Mandamus, C. Prohibition, C. Certiorari. Writs can be filed issued by the Supreme Court to compel a public authority to perform its duty. First, we have to read the answer carefully. Answer is mandamus. Mandamus is issued to public authorities to perform a legal duty and they are bound to do so. Next question. The writ of habeas corpus is a remedy for disputes regarding property rights, unlawful detention of person, violation of election procedure, removal of corrupt officials. Answer is option B, unlawful detention of a person. I have already told you with an example also. Habeas corpus means to produce the body of. Which of the following statements are correct? The writ of prohibition is issued to prevent a lower court from exceeding its jurisdiction. Certiorari is issued when after the lower court has passed an order. Only one, only two, both 1 and 2, neither 1 nor 2. Answer is both 1 and 2. Prohibition is issued when a high court to a lower court to squash an order passed without or in excess of its jurisdiction. Prohibition is to forbid, issued by a high court to lower court or a tribunal to stop its proceedings in a case beyond its jurisdiction. Prohibition is given before judgment. Certiorari is given after judgment. Next, Q warranto can be issued when a person is wrongfully detained, a official refuses to perform duty, a person holding a public office without a legal authority, a court acts beyond jurisdiction. It's a state PSC PYQ. Answer is option C. A person holds a public office without legal duty. Q warranto means by what authority? A writ issued by the court when a person is found occupying a public office unlawfully, that means without the required qualification. To prevent the misuse of a public office, a writ is issued by the eligible person or any citizens. Next question. This is a PYQ. With reference to the writs issued by the courts in India, consider the following statements. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Mandamus will not lie against a company even though it may be a government company. Any public-minded person can be a petitioner to move to the court to obtain a writ of Q warranto. Answer is both statements 1 and 3 are correct. Q warranto means by what authority are you holding this position or any public office position. Mandamus can be given against a private entity only if it's performing public functions. With reference to the writ jurisdiction of High Court, consider the following. Writs can be issued for enforcement of ordinary legal duty. Writ jurisdiction is a part of basic structure of the Constitution. High Court can never issue writs outside its territorial jurisdiction. How many of the statements are correct? Answer is both 1 and 2 are correct. High Court can never issue writs outside its territorial jurisdiction. This statement is wrong. This is the PYQs related to this topic. If you want some more interesting content like this, subscribe to our YouTube channel and join our Telegram channel by using this QR code AnusheelanIAS. You can also download our app AnusheelanIAS from your Play Store. This is today's lecture. Thank you.